dear students, welcome to the lecture of corporate laws and compliances, and in this lecture we are going to start with the chapter board meetings, and this is again a big chapter. This will be covering around 6 to 7 hours of the chapter will be there, and I have divided this chapter into various parts, into 6 parts basically. So let me start with the first part of this topic, that is board meeting, and this part will take around maximum of 2 lectures. So first complete this part, then move to the next part of this chapter. So without wasting any further time, let's start with the topic. So in board meetings we are going to study section 173 plus the rules we are covering here will be companies meeting of board and its powers rules 2014. So that is the name of the rule that governs this chapter, complete chapter. So today we are going to start with section 173 to 175, that is board meeting, provision related to board meeting, notice of board meeting, frequency of board meeting, that is how many board meetings need to be conducted in a year, how to conduct a board meeting. So what should be the quorum for the board meeting? Quorum means the minimum number of directors that is to be presented in a board meeting. So we'll discuss the meaning of word quorum and what is the concept of the quorum for board meeting. We're going to discuss that too in section 174. And there is another way of passing a resolution in the board by board that is called as passing of resolution by circulation. So here the resolution is passed not by conducting the board meeting, by circulating it to the various directors at their registered address, and then they forward their assent or dissent towards this resolution, and accordingly the decision has been will be taken, the resolution will be passed. So what is the provision exactly regarding this we're going to see in the near future. So first we're going to see the concept. So one thing that we have already seen from like very long time, that this is a company which is an artificial person. So it is managed by directors of the company, board of directors of the company, or the owner of the company, they are shareholders. So any decision taken by the board of directors shall be done by passing of resolution, which is passed at board meeting, where all the directors meet and pass a resolution, and on the basis of these resolutions the company take any decision. So we all know, the majority always prevail in case of Companies Act. So that's why we pass a resolution where majority of the director have to accept any particular matter which is being put in the resolution, and they need to vote in the favor of it. Majority of the directors, at least suppose there are 5 directors, so at least 3 directors should be in the favor of this resolution, and when they are in the favor of this resolution will be said to be passed in the board meeting. Okay. Now the next thing is how shareholder take decision. We have already seen this, that shareholder again pass either an ordinary resolution or special resolution. So both these resolutions are passed at either an annual general meeting or an extraordinary general meeting. Both are called as general meeting. So we are not going to discuss this part right now. We are on this part where we are going to discuss the provision regarding board meeting, because it's a duty of the board to meet frequently to take the decision, to discuss and review the business done by the company in the previous year. So all these things are being basically seen by the board of directors. Now let us see what is written here. So it says shareholder in general meetings and director acting collectively as board conduct the affairs of the company. So who conduct the affairs of the company? Shareholders and board of directors. Shareholders conduct by attending general meeting, and board of directors otherwise manage the affairs of the company. Therefore, the directors frequently meet to discuss various matters relating to the management and administration of the affairs of the company in the interest of shareholder, company and public at large. Okay, so basically what happened here, that the director frequently meet to discuss all the matters related to the management of the company. Whatever the matter related to management and administration comes in front of them, they have to discuss, to have a discussion on it, and may have to take certain decisions related to the management and affairs of the company. So these decisions are basically taken in the interest of the shareholders and in the interest of the company, and also in the interest of the public at large, because some transaction may be there which is not in the interest of the public but it is in the interest of the company. So that cannot be passed because it is obviously not in the interest of the public at large. So interest of everyone need to be considered here. Now the directors has the right to exercise all the powers of the company in which they are appointed as directors, except for those matters which by law are required to be exercised by the company in general meeting through shareholders. So basically what it says, that director has the right to exercise all the powers of the company. So all the powers of the company are basically need to be will be exercised by directors. Directors have that right. Okay, so except for those matters, so only those matters which is expressly mentioned in the law that this matter will be handled by the shareholders, only those matter will be handled by the shareholder, and other than that rest of the other matter will be considered by the company, by the board of director, and they are in the hands of the board of director. So generally you can say, generally all the powers of the company are vested with the directors, but only specifically which is mentioned in the law need to be exercised by the company in general meeting through shareholders. So shareholders take the decision on those certain matters which are specified, and on that matter also the implementation part will be done by the board of directors only. So board of directors oversees the management of the company to ensure that the interests of the shareholders are protected and goal of wealth maximization is achieved. So how the means what is the motive behind the board of directors in managing the company is they need to ensure that the interest of shareholders are protected, and the main motto of any company is profit maximization or wealth maximization. So you need to ensure, the board of directors need to ensure that that motive is being achieved. Now if you haven't noted this, you can note this down. Done. Now, we are starting with the concept of the meeting of the board, section 173. So let us see what is written here, then we'll understand that what is the concept of this. So first it says that this section requires the director upon who has the responsibility of the management of the company rest to meet and interact regularly. So basically it says that this section makes it mandatory for the director, which directors, those directors who has the responsibility of the management of the company with themselves. So those directors need to meet and interact regularly. So to meet and interact regularly, they conduct a meeting which is called as board meeting. So basically the aim here is to ensure that the powers which vest in the directors should be exercised collectively and every director should have the knowledge of the decision taken for the smooth conduct of the business operation. So basically what it says, basically the directors, we need to ensure the board of directors has taken any decision collectively. What do you mean by collectively? That is मिलजुल कर. Okay, in Hindi I am saying it मिलजुल कर. So they have taken the decision all together by considering the vote of all the directors collectively in an aggregate. They have taken vote of each and every director. Suppose there are 3 directors, Mr. X, Mr. Y, Mr. Z. So there are only 3 directors. So both of them, their assent or dissent or assent, this is basically required to pass a particular decision. So if any single director says that I want to pass a resolution, whether if these 2 directors are not giving their assent for this resolution, then whether it can be passed in the board meeting, answer is no. Why? Because the other 2 director has denied it. So the decision can be taken collectively only. There should be a mutual decision. It cannot be a decision which is passed by a single director. So a single director does not have any power with itself. The powers are given collectively to all the directors all together. They don't have any power. So in this case, when majority of the director gives an assent for any resolution, then only such resolution will said to be passed. Now, how frequently the board meeting need to be conducted? So there are 2 cases in this. Board meeting, there are 2 cases. First, incorporation, at the time of incorporation. So you can say it as a first board meeting, and then subsequent board meeting. First board meeting need to be conducted within 30 days of incorporation of company. Subsequent board meeting need to be conducted minimum 4 board meeting in a year. Maximum gap between 2 board meetings shall not be more than 120 days. And one more thing, one second, I have make a note. It has come recently, but I don't know, I don't think it's applicable on you, but just for your information I am saying that for the year 2021, this gap is allowed to be for 180 days. Okay, and now the board meeting for 2021 can be conducted with a gap of 180 days between themselves only for the period of 2021 because of the COVID-19 situation, and they can conduct this board meeting up to 30th September 2020. And again an extension has come to this, okay, where they can basically conduct it was like up to 30th September. One second, just give me a second, okay. Sorry, this is 30th June. Okay, actually the recent one more amendment has come, so that's why I got confused. So I'm just telling you that till 30th June 2020, please note this down because it may be applicable whenever you are seeing this video. So I am just teaching you to cover this. So for the year 2021, there was a relaxation given where this more than 120 days has been extended for 180 days. Okay, that is extended for 180 days. Okay, from the previous board meeting. What is the effect of this? I'm going to tell you right now. Just note this abhi. Okay. So by 30th June they need to conduct the next board meeting, and then there is a provision to conduct that you can conduct a board meeting through video conferencing. So in that also there is certain relaxation that has come for COVID-19, but otherwise the provision is different. So we are going to study both of that. And by 31st, now the announcement has came that by up to 31st December you can conduct the board meeting through video conferencing, and there will be not an issue that this minimum 4 board meeting also can be conducted through video conferencing. Okay, now you can note this down, then I'll explain you with an example. Now suppose, done, pause it and note it. Okay, now suppose you have the date of incorporation of company is 1st August 2020. So the first board meeting you need to conduct is up to 30th August 2020. So in up to the end of the year will be 31st March 2020. So up to this year you need to conduct at least 3 more board meetings. So let us see quarter wise, because we need to have a gap of minimum 120 days and minimum maximum 120 days and minimum 4 board meetings in a year. So this is the first board meeting. So this is the first quarter for this. So the first quarter for this will be July, August, September. July to up to September you have done in the month of August. Then from August you need to calculate 120 days. 120 days, if I divide it by 30, it will come to 4 months basically. Okay. So August, September, October, November and December. So up to 31st December you need to conduct one more board meeting. Suppose you done it on 30th November 2020. The gap between these two is September, October, November, 30, 30, 60, 30, 90 days. So it is allowed. Okay. So it is second board meeting. Okay. Now third and fourth, it's become compulsion for me because my year is like less than 12 months. So I have to conduct 2 board meetings in the further 4 months. So suppose the next board meeting I had conducted on 1st of February 2020 and next I had conducted on 30th or March 2020. So I have done the 4 board meeting within the time frame. Okay. Now the second year started. From this year you will going to understand. The year is from 1st April 2021 to 31st March 2022. This is a year. The next subsequent year. So for this first board meeting, so within 4 months from this date, the last board meeting held on 30th March. So from 30th March we are going to calculate this. So let us see the quarter. April to June. So in 30th March, then April, May, June. So within this 3 months I have to conduct one board meeting. So suppose I have conducted by 30th June. The gap between the two will become 30th March to 30th April, 30th May, 30th June. So that is 90 days. Okay, it's enough. Then in the second quarter that I have is July to September. So in this I have done a board meeting on 30th September. So 30th June to 30th July, 30th July to August, 30th August to 30th September, again 90 days. Then October to December, let us do by 30th December 2021, again 90 days. Then take it 90 days and by 30th March. So yes, you have completed with this. Okay, so if I because this 120 days is the maximum criteria. So suppose your first board meeting is on this date, you cannot go beyond 30th October. So this is the last date before which you have to conduct the board meeting. But again, you have to follow both the condition where that is I have mentioned here. You need to follow that you have to have at least 4 board meeting in a year with a gap of not more than 120 days between 2 consecutive board meetings. Consecutive board meetings, that is between first and second board meeting, between second and third, between third and fourth. That is the consecutive. Okay, and then there is 2 provisions. Again, I want you to see this. It says section 173 subsection 1 says every company shall hold a board meeting of its board of its director. The first board meeting shall be within 30 days of date of its incorporation. The subsequent board meeting will be thereafter hold minimum 4 board meetings every year and with a gap of not more than 120 days between 2 consecutive board meetings. So we have an example also here. Before that, let us see a relaxation. There is a relaxation for certain companies. Let us see for whom. So what it says, section 8 companies applicable to the extent the board of directors shall hold at least 1 board meeting within every 6 calendar year. So for section 8 company, you have only one thing, that you need to conduct at least 1 board meeting within every 6 calendar month. So if I conclude this, at least 2 board meetings in a year in such a way that suppose April to 31st March our period is there. So April to September is your first 6 months. So between this you need to have a first board meeting, and then between October to March you need to have a second board meeting. That is the conclusion that we can come out with from this. So the next thing is the OPC, 1-person company, small company, dormant company, private company, startups, not all private companies, the startup ones that need to have complied with the above provision if they had conducted the board meeting in each half of the calendar year, like this, in each half of the calendar year, that is at least 2 board meetings in a year, but in a way which falls in each half of a calendar year that I had explained here. And the gap between these 2 board meetings shall not be less than 90 days. So here the thing was, it shall not be more than 120 days, and here it is, it shall not be less than 90 days. So the gap between 2 board meetings should be at least for 90 days. So at least 3 month difference between the 2 board meeting is required. So that is, for example, I am deleting this now. Okay. April to September. This is your first half. In this, I am conducting a board meeting in June, 30th June. And from October to March, now I have to conduct the second board meeting. So I need to calculate the days. So that must be at least 30th June to 30th July, 30th August, 30th September. So it should be after 30th September. Okay, after 30th September, because at least 90 days gap is required. So first condition is in each half of the calendar year. Second condition is that at least 90 days gap between 2 consecutive board meetings. This is for OPC, dormant company, small company, and startup private company. Okay, that's it. Now, there is an example which it says, in case a company conducts its board meeting on 2nd April 2019, the next meeting must be held within 120 days of the date of this date. That is at least from 2nd April to 2nd June, 2nd May, 2nd June, 2nd July, 2nd July is 3 months. Okay, that will be 90 days. Then we add 30 days in it, that will be around 31st July. So it shall be before, ideally before 31st July, and by 31st December the company shall conduct minimum 4 board meetings. They have taken a year as a calendar year, so they are saying that minimum 4 board meetings in by 31st December, and if our year is for April to March, then by 31st March it should be for at least cover at least 4 board meetings. Okay, including the meeting which has already been conducted in 2019. The board may go beyond 4 board meetings in a calendar year depending upon the urgency of any. Now also understand, this year means calendar year. Calendar year. So we are going to consider from year from 1st January to 31st March. Earlier I was telling you in that way because the 31st December, sorry. The company generally have that financial year, so we need to follow. If we follow in that way, we automatically follow in a year only. But as a practically provision, what provision says, it says in a calendar year at least 4 board meetings, minimum 4 board meetings with not more than 120 days gap between 2 board meetings. That's it. Okay. You can go beyond 4, but you cannot go below 4. That is the thing. Now, participation by the directors in the board meeting. Now, you can note this down. Now, participation by directors in board meeting. Section 173, subsection 2. Now, how the directors are going to participate in the board meeting. I already told you. This is the normal provision, and we are also going to see the COVID provision, that what the COVID leads to the changes in this board meeting thing. Okay. So 173 says basically a director may attend the board meeting in person, that is physically they can go wherever the meeting is conducted. Mostly it is conducted in at the registered office of the company, or they can attend through video conferencing, okay, like a video call that you say, okay, or through other prescribed audio visual means. So there may be other prescribed audio visual means by which you can like listen to someone plus you can see their video. Both the things is possible. So either in person or through video conferencing or through other prescribed audiovisual means, anyone can attend the meeting. Now, this diagram says that in person, through video conferencing and other audiovisual means, and this other means is mentioned in Rule 3 of Companies Meeting of Powers Rules. Okay. Now, what do you mean by the term video conferencing or audiovisual means? So, it refers to audiovisual electronic communication facility employed which enables all the person participating in the meeting to communicate concurrently with each other without any intermediary and to participate effectively in the meetings. It's very simple. It basically says it should be a medium where you can communicate with each other, where you can see your listen to the audio, see the video, and all the person who are attending the particular meeting can communicate concurrently, okay, and with each other and without any intermediaries. There should not be any intermediary to whom you are saying that I want to say this, then he is conveying your communication. So there should not be any intermediary between this. You should be able to communicate directly. Suppose you are I am communicating with you directly. There is no medium by which we are talking. But when you like ask any query, you have to go through superprops towards me. So in that case, you have to come through superprops to me. So there is an intermediary between us. So in this case, there is no intermediary. We can communicate directly like I am teaching you right now. Okay. And to participate effectively in the meeting. So everyone can participate in the meeting effectively. Now what should be the essentials of audio-visual means? Now according to section 173 subsection 2, audio-visual means it should be capable of recording and recognizing the participation of director. So that whatever the director is participating, we should be able to record it and recognize the directors who are attending it, and recording and storing the proceedings of such meeting along with the date and time. So again we are able to record and store the proceedings of the meeting. Okay, we are able to record and store the proceedings of the meeting along with the date and time of the proceedings. So obviously you can record and recognize the participation of the director, and then you are able to record and store the proceedings of such meeting along with the date and time. So you can see that normally the video has the date stamp and time stamp on them. So we should need to have a recording facility in that way where the date and time is visible. Now matters which cannot be dealt with within a meeting through electronic mode. So it says these following matters cannot be dealt through video conferencing or electronic mode. And again there is some change in this because of the COVID-19 situation. So we're going to see that also. But here there are certain matters which are very important matters which cannot be which is considered as so important that you cannot consider them through video conferencing. You should conduct the meeting in person, and all the directors should be present in the meeting in person and vote physically, not electronically. So the first thing is approval of annual financial statement. So first thing is the approval of annual financial statement. So whenever a board meeting is conducted for the approval of annual financial statement, it is to be conducted through board meeting first, and second, all the directors need to be present in person. Okay, and the second is approval of board report. Again, whenever the board report is approved in the board meeting, a director has to present physically. Now the prospectus, if the approval is done through prospectus, then again the same thing. And then audit committee meeting, when there is an audit committee meeting for consideration of financial statement including consolidated financial statement, for that purpose whenever any audit committee meeting is there, then the director should become in person. Okay, approval of the matter related to amalgamation, merger, demerger, acquisition and takeover. So all these decisions it is advisable to the directors to come in person, not through video conferencing or other audiovisual means. But if the quorum is present, what is quorum we are going to see in coming slides. But if the quorum is present, then the director who are like beyond that quorum can attend the meeting through electronic mode, through video conferencing or through audio visual means. So like the quorum is required of minimum 2 directors, for example, and there are 4 directors who are present. So 2 directors need to be present in person, and rest of the 2 directors can present through either video conferencing or audio visual means. Okay. So it says it is provided that where there is quorum in a meeting physically, then through physical presence of director, any other director may participate through video conferencing or audio visual means in such meeting on those matter also, on those 4 matter also which we have discussed, okay, which are not permitted to be deal with the meeting through video conferencing or audio visual means. The next thing is for the period, this is the amendment thing. For the period beginning from the commencement of company's meeting of board and its proper amendment rules. So this basically begins from 19th March 2020. This is the date of lockdown if you remember, and ending on 30th June 2020. So for this particular period, the meeting on the matters mentioned above may be held through video conferencing or other audiovisual means in accordance with Rule 3. So, during this period, even if any directors, all the directors are attending meeting through video conferencing for conducting these matter also, then also it will be not be considered as non-compliance of Rule 4. Okay, what it says, then the meeting on the matters mentioned above may be held through video conferencing or other audiovisual means in accordance with Rule 3. Rule 3 will tell you the manner of doing the video conferencing. And right now, this date is changed to 31st December 2020. But this amendment has come on 28th September 2020, this one. This might not be applicable for your examination, but it's my duty to tell you that what is the current thing, okay? But on your examination, you have to write this thing, okay? Now, procedure of Rule 3. This is the Rule 3. It says the procedure of board meeting through video conferencing or audio visual means. Let's start with the topic. Procedure of board meeting through video conferencing or audio visual means. So Rule 3 basically tells about this procedure. Before understanding towards this point, we can have to see only one thing. What is quorum? Because we'll see exact provision in section 174. But right now, just understand the meaning of the word quorum. It means the minimum number of directors required to be present in the meeting to form a valid meeting. So basically, we need such a minimum number of directors, which is mentioned in the 174 section, that is required to be present physically in the meeting so that we can conduct a valid meeting. So at least for example, it says basically at least 2 directors or 1/3 of total directors. Let's say total directors are 6. So at least 2 directors are required. So if the total directors are 9, then it says at least 3 directors are required, whichever is higher. One second. Whichever is higher. Okay. So we'll see in detail later on. I'm just telling you the concept so that you were able to understand the procedure. Whichever is higher. So at least 2 or 3. So higher is 2 director, and here in both cases it is 2. So at least 2 directors need to come to form a valid meeting. So if below 2 directors come, then meeting cannot be happen. It need to be adjourned. That it need to be postponed in the to the next date, whatever it is, whatever we're going to understand right now. Okay, but right now, just for understanding this procedure, let us see. Quorum means minimum number of directors that is required to be present in the meeting, and if they are not present in the meeting physically, then meeting could not be held. Okay. Now, what is the procedure? It says every company shall make the necessary arrangements to avoid failure of audio visual means or video connection. So basically the connection should be proper, that should be that the kind of arrangement should be there, that video connection should not collapse during the meeting. Okay, and the chairperson of the meeting and the company secretary, if any, shall take due and reasonable care of the following things. First is to safeguard the integrity of the meeting. So basically they need to take care about the integrity of the meeting to ensure that the integrity of the meeting is maintained, sufficient security is there in the meeting, and identification procedure is being adopted. So sufficient security regarding that whatever discussion is there in the meeting, they are not being taped by any other director, recorded by any other director, misused by any person, or any intermediary should not be there who is like listening to our conversation. And there should be an identification procedure by which everyone can identify the director. The director is being identified through this procedure. Okay, and basically we are, before conducting a meeting, we should be able to identify all the directors present in the meeting, and no person other than director should be attending the meeting. Now, to ensure the availability of proper video conferencing or other audiovisual equipment or facilities for providing transmission of communication for effective participation of the directors and other authorized participants. So basically it says we need to ensure that we have proper like equipment by which we can do video conferencing and audiovisual meeting like thoroughly without any interruption, and communication can be done effectively. Every director is able to participate, and every authorized person which are allowed to participate in the meeting are able to understand that what is going on in the meeting, and then we are able to record the proceedings and prepare the minutes of the meeting. So obviously this is the work of company secretary. We have to prepare the minutes of the meeting, and we need to record the proceedings, whatever happened in the meeting, and we need to store for the safekeeping and making the tape recordings or other electronic recording mechanism as a part of the records of the company at least before the time of completion of audit for that particular year. So the recording that you have done in point C, you need to store it in a place for a certain period, for at least till the time the audit has been conducted for that particular company, the yearly audit. Okay, till that time at least you need to store these recordings. And to ensure that no person other than the concerned director is attending or have an access to the proceedings of the meeting through video conferencing or audiovisual means. Now this is the stricter rule that only the director is liable to attend the meeting. No person other than the director can attend the meeting. Okay, so that thing is to be ensured by the company secretary and by the chairman of the company. And also they need to ensure that the participants they are attending the meetings are able to hear and see the other participants clearly during the course of meeting. And however, the differently abled person may make a request to the board of director to allow any other person to accompany him. So if any person who is unable to listen or unable to see can have the right that they can like call any other person and who can guide him for doing all the things, for using the audiovisual means. So any other person can join him for this purpose. Okay, now I'm like stopping this video here only because we have like couple of topics left, so we'll be taking one more session to complete it. At least we have a notice of board meeting provision and other process for that, how we have to conduct the board meeting, basically how the board meeting is conducted by the directors, what is the schedule of the board meeting and everything, and basically the provision regarding board meeting, and certain questions we are going to practice, and we are going to see how the resolution is passed by circulation. So we'll be needing one or two lecture more and we'll be done with this chapter. In the next chapter we are going to part we are going to start with notice of board meeting. So please revise this lecture. We have completed this two things. First, frequency of board meeting, section 173 subsection 1, And subsection 2, participation by director in board meeting and participation through audio-visual means. And what is the procedure to participate through audio-visual means? So we have completed these things. So let's discuss notice of board meeting in the next video. Thank you.